Past the hour now, so did Lois Lerner waive her Fifth Amendment rights, and in doing so make a substantial legal error in her defense. Here is what she said yesterday, right about this hour.
Because I'm asserting my right not to testify, I know that some people will assume that I've done something wrong. I have not. One of the basic functions of the Fifth Amendment is to protect innocent individuals, and that is the protection I'm invoking today.
So we had our brain room do a bit of digging on this commonly accepted law when it comes to the Fifth Amendment privilege. We found this now. A common rule is once a witness voluntarily reveals incriminating facts, he or she may not refuse to disclose the details related to those facts. And a defendant who takes the stand on his own behalf cannot then claim the privilege against cross-examination on matters reasonably related to the subject matter of his or her direct examination. Congressman Trey Gowdy, Republican, South Carolina, the first to bring this up yesterday. He joins us today as a follow-up, and welcome back here. You had a bit of a head start on this because you're a former federal prosecutor. You did that for 5 or 6 years, and you called her out immediately. Why?
Well, you know, Mr. Cummings from Maryland said we ought to run this hearing like a courtroom, so that got me thinking about my previous job, and I can promise you in a courtroom, you don't get to say I didn't rob the bank, but I'm not going to answer the prosecutor's questions. That would never happen. So Brown versus U.S., which is a Supreme Court case from the 1950s, makes it abundantly clear you can't do what she did yesterday if we were in a courtroom.
It doesn't appear that Chairman Darrell Issa understood exactly where you were going with that. Now, he is not trained in law, by the way, but a few hours later he seemed to come around to think that you were right, that she needs to come back. Does this mean that Lois Lerner comes back before your committee?
Well, Bill, among Chairman Issa's many wonderful qualities, you're right. He's not an attorney, which is something he's very proud of, but he does listen to those of us who couldn't do anything else for a living and went to law school. And he did last night. And he's got a lot of options at his disposal, but let's play this out. Let's assume he brings her back. I promise she's not going to make the same mistake today that she made yesterday. She's going to invoke. You can't make someone talk unless your name is Jack Bauer. You can't force someone to talk. So are we going to hold her in contempt? Are we going to put her in jail? Are we going to offer her immunity, which I would not be a fan of? Or are we going to try to build a case without using her testimony? All of that will be decided at the chairman's speaker level and not at my
Okay, so just
level.
to be clear on this now, even if you do bring her back, she can raise her right hand, invoke the Fifth Amendment, and not answer any questions, right?
Bill, you can't make somebody talk. I've got 2 kids. You can't, unless you're willing to do what Jack Bauer does, you can't make people talk.